Whether you have an employment, criminal, family, corporate, or personal injury matter, legal issues can be puzzling. The lawyers at Devry, Smith & Frank make all the pieces fit together.
Good morning. My name is Alexandra Tratnik, and I've been with the firm for about 2 years now. My practice areas include employment law, commercial litigation, collections and debt recovery, as well as some family law. Today I'm going to discuss with you the topic of bullying, harassment, and human rights in the workplace. The topic of human rights in the workplace is quite broad and includes an array of issues, from an employer's duty to accommodate an employee with a disability, to breastfeeding in the workplace, to systemic discrimination in the recruitment and hiring process. As our time today is a bit limited, I'm going to focus more on workplace harassment and violence, including bullying, and the employer's obligations regarding the same. In Ontario, protection from harassment and violence is provided 2 ways. Number 1, under the Human Rights Code, and number 2, under the recent amendments to the Occupational Health and Safety Act as a result of Bill 168. The Ontario Human Rights Code states that every person has a right to equal treatment with respect to employment without discrimination or harassment because of race, ancestry, place of origin, color, ethnic origin, citizen, creed, the list goes on. It's important to remember that the right to equal treatment with respect to employment covers every aspect of the workplace environment and the employment relationship. This would include job applications, recruitment, training, covers rates of pay, overtime, dismissal, layoffs. Types of workplace harassment that employees may experience include sexual harassment, teasing, intimidation or offensive jokes or innuendos, display or circulation of offensive pictures, materials, unwelcome, or offensive, intimidating phone calls, for example. However, as you can see, not all types of these harassments fall under a code-protected ground. That's why 2 years ago, Ontario enacted Bill 168 and created an amendment to the Occupational Health and Safety Act, prescribing strict new mandatory standards aimed at reducing the risk of violence and harassment in the workplace. The Act broadens and extends the definition of workplace harassment beyond the code-protected grounds. It imposes a positive obligation on employers to take precautions for the protection of the employee if there is a likelihood that the employment may be subject to bullying or other forms of harassment and violence. It's important that employers and employees alike can identify bullying and other types of workplace harassment. Generally, bullying is an aggressive behavior of harassment or violence, usually directed to one person. The Act separates workplace violence and harassment into 2 definitions, which are provided in your outline there. Workplace harassment is defined as engaging in a course of vexatious comment or conduct against a worker in a workplace that is known or ought to be reasonably known to be unwelcome. One example of this would be spreading rumors in the workplace. Whereas actual physical force, an attempt to exercise physical force, or a threat to exercise physical force, all fall under the umbrella of workplace violence. An example of workplace violence would be leaving threatening notes or sending threatening emails to a workplace. A good example of workplace bullying and how costly it can be for employers can be seen in the BC Supreme Court's decision in Sulls v. Canada. Here, an RCMP employee was harassed by her superiors to the extent that she became clinically depressed and had to accept a medical discharge. The employee was subject to vulgar and aggressive language from her supervisors and received threats to her employment for ongoing medical leave due to pregnancy complications. The court found that the bullying had a severe negative impact on her mental health, affecting not only her ability to work, but also on the extent to which she can enjoy her life and function as a member of her family and her community. As a result, the court awarded the employee a total amount of $950,000, which included damages for past and future income loss and general damages. Bullying doesn't just happen to your kids at school, it also clearly affects working adults and the atmosphere at work. To provide a little bit of a background as to why these laws were enacted, Bill 168 was introduced mainly as a result of the lobbying efforts of Lori DuPont and the families of Lori DuPont and Teresa Vince. Lori's case, she was killed by her ex-boyfriend in 2005 at a Windsor hospital where they both worked. The hospital there was aware that Lori was being harassed by her boyfriend at work, and that the situation was escalating. However, they failed to discipline the boyfriend and failed to intervene. After stabbing Lori to death, the boyfriend took his own life. In Teresa Vince's case, she was shot in the face and killed in Chatham by her boss, who had sexually harassed her for more than a year and against whom she had filed a harassment complaint. The amendments to the Act are based on the theory that workplace violence can be foreshadowed, and in that many cases it's predictable. By heeding the signs of danger, communicating clearly, and taking a proactive approach, violence at work can be prevented. As I outlined there in your handouts, the Act imposes obligations on the employer, which I'm going to go over briefly for you. As a preface, though, it's important to note that these laws do not apply if the number of employers regularly employed is 5 or fewer, unless the inspector orders otherwise. First, employers must perform a workplace violence risk assessment to formally evaluate the risks arising from the nature of the workplace, the type and conditions of work. Second, the employers must prepare a policy based on the findings of their risk assessment. This policy is supposed to be reviewed as often as necessary, but at least once per year. Next, employers must implement a program identifying the steps required to address the workplace risks and conditions identified in the risk assessment. The program must, among other things, include measures and procedures for employees to report incidents of workplace violence, as well as set out how the employer will investigate and deal with incidents or complaints of the violence. Fourth, employers must address the risks to employers arising from domestic violence, where they are aware or ought to be aware that the employee may be exposed to domestic violence in the workplace. The law does not really explain what reasonable precautions employers can take to protect the worker, but employers should be looking for warning signs of domestic abuse. A person who has a personal relationship with a worker, such as a spouse or a former spouse, may physically harm or attempt to harm that person at work, and the employer needs to be on the lookout for this. Fifth, employers should also keep a record of persons with violent history and advise employees if they may come into contact with a person who has a violent past in the workplace. However, it's important to note that only personal information necessary to protect the employee from physical injury should be disclosed. Employers will need to consider the privacy rights of these violent employees and may want to seek legal advice in this circumstance. Employers are also obligated to provide training regarding the program and the policy to all employees. As you can see from the list above, employers have quite a bit of discretion through the development of their own internal policy and program to determine what remedies may be available to an employee who suffers from violence or harassment in the workplace. I'm going to go over just a couple of cases for you. In a 2011 decision of Universal Workers Union and Testing Pipelines, the Labor Relations Board was tasked with deciding whether to hold up a 5-day suspension imposed on a worker who threatened to kill his foreman on 2 separate occasions. In making its decision, the board stated no employee should ever threaten to kill anyone else at work, much less his foreman. The union, on behalf of the employee, argued that the worker was under considerable amount of stress. It was recently fueled by a separation with his wife and children. Ultimately, the board decided that these threats fit squarely within the definition of workplace violence and that the employer is required to act both to deal with the unacceptable behavior and take steps to ensure that its policies are known and understood. The suspension was upheld by the board. One other example, in 2011, an arbitration decision, City of Kingston versus QP Local 109. It dealt with an employee with 28 years seniority who was bullying a coworker. The main allegation relates to when the woman made a death threat to her local union president. The arbitrator held that under the Bill 168 amendments, an employer must react to the allegation of threat. It must not be trivialized. In this case, however, it was noted here that nothing in the OHSA requires an employee found to have committed an act of workplace violence to be automatically terminated. While there are a variety of ways to deal with the matter, it is ultimately for the employer to determine at the end of an appropriate investigation and consideration of the options. In this case, the city decided to terminate the employee, factoring in the employee's history of harassment in the workplace, and the arbitrator upheld its decision. I'm going to just briefly outline some remedies available to employees who are faced with harassment or violence in the workplace. They can file an application with the Human Rights Tribunal of Ontario if harassment is based on one of the prohibited grounds I mentioned earlier. The tribunal has a range of remedies that it can impose, such as damages or reinstatement, as well as public interest remedies. If the workplace violence or harassment creates a situation where it becomes untenable for the complainant employee to continue working, the employee will also have the option to file a claim for constructive dismissal. Now, civil claims can also include damages for human rights breaches. There might be an internal complaint process with the employer. There's a possibility of commencing claims based on intentional torts, such as intentional infliction of mental suffering. The Act does not create a complaint mechanism for workers who have experienced violence or harassment. Rather, the Act simply imposes obligations on the employer to develop these policies and programs. Therefore, employees' remedies will be limited to those set out in the workplace policy program as determined by the employer. Given that the workplace may be unionized or not, given the nature of the harassment may be personal or based on human rights, there are several options available to employees experiencing workplace violence and harassment. Employees should be aware of these options and tailor their human rights policies and programs accordingly. That's it. Thank you very much.